Welcome to Deep Dive. Today we're taking a closer look at a question that, well, many non-immigrant visa holders in the US undoubtedly ponder. Can I actually own property here? And, if so, what are the intricate rules I need to navigate? It's a topic that might seem straightforward at first glance. After all, buying a home is a fundamental aspiration for many, a significant personal and financial step. But for those on non-immigrant visas like the H-1B, there are some truly critical distinctions. These can directly impact your immigration status and, frankly, your future in the U.S. And while we'll often use the H-1B as a primary example today because, well, it's so common, keep in mind that the core principles we discuss regarding work authorization and property management, they generally apply across many other non-immigrant visas too, things like L1s or E2s, all of which carry strict limitations on employment outside of your authorized sponsor.
That's a vital point to establish up front.
Yeah.
The dream of U.S. property ownership is indeed accessible to a broad spectrum of individuals, that's true. But the practicalities of managing or even renting out that property demand a nuanced understanding. Our mission in this deep dive is really to guide you through these complexities, helping you clearly distinguish between what's perfectly permitted and what could, without you even realizing it, inadvertently create significant issues for your visa. We've gathered some really important material to help you understand this often misunderstood area.
Absolutely. By the end of our conversation, you'll have a much clearer, much more practical understanding of how to approach property investment in the U.S. responsibly, all while safeguarding your visa. So let's get right into it.
Okay, let's unpack this core question. The first piece of information, and thankfully it's quite clear, is this. Simply holding an H-1B visa, or most other non-immigrant visas, does not prevent you from purchasing property in the United States. Many people assume there are stringent citizenship requirements to own real estate, but that's not generally the case for the act of buying itself.
We've hit on a crucial point there, one that often surprises people. According to U.S. immigration attorney Abisha Parikh, the right to own real estate in the U.S. is surprisingly broad. It extends to virtually anyone, whether you're a non-immigrant visa holder, maybe a student here on an F1 visa, a temporary worker, or even an overseas investor who may never set foot in the country. There are simply no citizenship or specific residency requirements that dictate who can hold title to property in the U.S. You could buy a home, a commercial building, land, any other type of real estate. This is a fundamental aspect of property rights in the U.S. that's often misunderstood. Many people believe you need to be a permanent resident or citizen to even consider it.
Right.
It's a universal right, really, that separates ownership from immigration status.
That's a powerful distinction, a very fundamental right. So the good news is you can buy, but as with many things immigration-related, the devil is truly in the details, isn't it? The real challenge, and where we need to be incredibly careful, arises when you move beyond just owning the property and start engaging in activities like renting it out or managing it directly. This is where the lines can become blurry and the potential risks for your immigration status can increase significantly. It's not about the initial purchase, but rather what you do with that property afterward, right?
Precisely. That's the crux of the issue. If you, as the non-immigrant visa holder, personally undertake activities related to managing your property for profit, those actions can easily cross into what immigration authorities define as unauthorized employment. And this is a very serious matter. Your visa, particularly an H-1B, is issued for a specific purpose, to work for a designated employer in a particular role. Your work authorization is strictly confined to that employer and that scope of work, as listed on your visa authorization documents. Engaging in other forms of work, even something seemingly innocuous like managing your own property for profit, can be viewed as working outside the scope of your authorized employment. This is critical for you to understand because, well, the implications can be quite severe. It's not just a theoretical concern. We've seen situations where this leads to challenges with visa renewals, requests for additional evidence from USCIS, or even denials for future green card applications. You see, immigration officers during interviews or when reviewing applications often scrutinize financial activities. If they uncover evidence of direct property management, it can trigger questions about unauthorized employment. And that could potentially lead to significant delays or even a denial of your immigration benefits. The system is designed to prevent visa holders from competing in the U.S. labor market in ways not explicitly authorized by their visa.
That makes the stakes incredibly clear.
Wow. So what does this all mean for someone wanting to benefit from property ownership without risking their visa? How do we effectively distinguish between what's considered perfectly acceptable, what you call passive income, and those active roles that could really jeopardize your status? Sounds like a very fine line,
Yeah.
but one that's incredibly important to understand down to the practical actions.
It truly is a crucial distinction, and getting it right is fundamental. Let's define passive income first, as this is generally where you want to stay. This primarily includes rental income that you do not manage yourself.
Okay.
What does that mean in practice? Well, it means someone else, a professional entity, handles all the day-to-day responsibilities. Things like finding and screening tenants, drafting leases, dealing with maintenance requests and repairs, collecting rent, handling evictions if necessary, and so forth. Essentially, you're receiving income from an asset, but you are not involved in any operational tasks whatsoever.
Completely hands-off. Yes, exactly. Other forms of passive income, like dividends from stock investments, interest from bank accounts, or capital gains from selling an investment. Again, where you're not actively trading like a business, are also perfectly acceptable because they don't involve your labor or active management. The key element here is truly being hands-off, acting purely as an investor. Now, when we talk about active roles, this is where you can run into significant trouble. These are the activities that immigration authorities might interpret as unauthorized employment, even if it's for your own property. Think of it this way. If you're doing anything that a professional property manager or a business owner would typically do, you're probably in the red zone. This includes actions like personally screening potential tenants, collecting rent payments directly from them, handling or coordinating repairs and maintenance issues yourself, or actively advertising and listing your property for rent, especially for short-term platforms like Airbnb. Furthermore, treating property investment like a full-time business, for example, frequently flipping houses by constantly buying, renovating, and selling them for profit, is also very much in the problematic category. These are entrepreneurial activities that require active labor and management, which are typically outside the scope of a non-immigrant work visa.
That makes the distinction incredibly tangible, drawing a clear line between investing and working. So if you're personally interviewing potential renters, or calling a plumber for a leaky faucet, or even just updating an online ad for your vacant unit, you could be straying into that active territory. But what about the gray areas? For example, what if a tenant calls you directly about an urgent repair, and maybe your property manager is unreachable for a moment? Is even a minor, isolated intervention considered active and therefore risky? What are some real-world consequences you've observed from people crossing that line?
That's an excellent question, and it really highlights the nuances we're talking about. Even a seemingly minor urgent intervention, if it involves you directly performing or coordinating labor related to the income-generating activity of the property, carries a degree of risk. Now, the immigration system often looks at the pattern of activity rather than just one isolated incident. But repeated or documented instances can certainly be problematic. It's about demonstrating consistent intent to remain hands-off. I recall one client who was incredibly meticulous about this. Their property manager was their primary point of contact for everything. One time, a tenant bypassed the manager and called the client directly about a burst pipe late at night. The client's first instinct, naturally, was to take charge. But instead, they immediately directed the tenant back to the emergency number for the property manager and then followed up to the manager, documenting the interaction.
Smart.
That level of discipline, referring all operational issues to the authorized manager, is key to avoiding future headaches. It shows a clear separation. The consequences, as you mentioned, can range from requests for evidence RFEs during visa extensions or green card applications, where you'll have to provide extensive documentation proving you weren't engaged in unauthorized employment, to delays or, in more severe cases, outright denials. It's not a hypothetical risk. These are very real challenges that arise when the lines are blurred.
That really underscores the importance of being incredibly disciplined. So if you're a non-immigrant visa holder who wants to benefit from property ownership without risking your status, what are the practical steps you can take to ensure you stay firmly on the right side of those immigration rules? How can you truly be a hands-off owner in the most effective and compliant way?
Well, the most direct and universally recommended approach for being a hands-off owner is to hire a professional property management company. This isn't just a convenience, it's a critical compliance strategy. They will handle virtually everything related to the property's operation, from marketing vacancies to thoroughly screening and placing tenants, managing all tenant relations, think complaints, emergencies, lease renewals, and crucially, collecting rent and coordinating all necessary repairs and maintenance. This completely removes you from those daily landlord tasks that could be interpreted as unauthorized employment.
Right, you become purely an investor.
Yes, exactly. An investor, not an active manager. When choosing a property management company, it's important to vet them carefully, of course. Look for companies with a solid reputation, clear contracts outlining their responsibilities, and ideally, experience working with absentee or foreign owners. Ask for references, understand their fee structure, usually a percentage of the monthly rent, and ensure they are responsive and transparent in their communication. Remember, while this service comes with a cost, you should consider it an investment in protecting your visa status and, frankly, your peace of mind. Without them, you'd be directly performing tasks that could put your visa at risk. And critically, you should avoid drawing a salary from the property itself or performing any work that could be interpreted as authorized employment. Any income from the property should be purely passive, distributed to you without any direct labor on your part. And even if you have trusted friends or family in the U.S., letting them manage the property on your behalf still involves you delegating that management. If they're acting as your agent, immigration authorities could still scrutinize that relationship for evidence of your indirect involvement.
Ah, interesting.
Professional management creates that clear, documented separation.
That strategy sounds like the most robust way to secure the financial benefits of property ownership, whether that's through appreciation or passive rental income, while staying well within the bounds of your visa requirements. It truly underlines the importance of good professional help in navigating these waters. It's a trade-off, isn't it? You might give up some direct control, and there's a cost involved, but you gain compliance and significantly reduce your personal risk. Okay, so beyond the critical distinction between passive versus active roles, there are other important practical and financial details for non-citizens considering buying property in the U.S. It's not just about immigration status. There are a number of logistical and financial hurdles to be aware of.
Absolutely. Let's delve into those. First, when it comes to documentation, foreign nationals typically need several key items. A valid passport is a given, of course, but you'll also need robust proof of funds, like detailed bank statements, to show your purchasing power. A U.S. tax identification number, or TIN, is also essential, especially for tax purposes and often for opening bank accounts or securing financing. And if you're planning to finance your purchase, pre-approval from a lender is also a standard requirement.
Right.
The absence of any of these can significantly delay or even halt a transaction. Next up, mortgages and financing. Now, while some U.S. banks do offer mortgage programs specifically tailored for foreign buyers, the conditions are often quite different from those for U.S. citizens or permanent residents. You should generally expect heavier down payments, often in the range of 30% to 40% of the property value.
Wow. Yeah.
Rather than the lower percentages available to residents. Interest rates might also be higher, reflecting a perceived increased risk. And you'll typically encounter more extensive paperwork and a more rigorous underwriting process. The primary reason for these stricter conditions is the common lack of a U.S. credit history for foreign buyers.
Makes sense.
Building a credit score in the U.S. takes time, and without it, lenders have less data to assess your creditworthiness. This is why many foreign buyers, finding these conditions quite challenging, actually prefer to pay in cash if they have the liquidity. It just simplifies the purchase process considerably.
Okay.
Then there are taxes and ownership. It's crucial to understand that property owners in the U.S., regardless of their visa status or citizenship, are responsible for paying local property taxes. These taxes are assessed by local government entities, like counties or municipalities, and they can vary significantly based on the property's value and location.
Right, that varies a lot.
It does. Property taxes are typically paid annually, and the revenue often funds local services like schools, police, and roads. Failure to pay these taxes can lead to liens on your property, fines, and even foreclosure, so it's a non-negotiable part of property ownership. You'll need to factor this ongoing expense into your budget. And finally, a point that really cannot be overstated regarding immigration status. Property ownership in itself does not grant any contact with immigration authorities, nor does it provide any resident status whatsoever.
That's key.
Owning a home doesn't give you a green card, it doesn't give you the right to stay indefinitely, and it doesn't simplify your visa renewal process. A valid visa is still absolutely required for legal stay and work in the U.S. What's fascinating here is this clear separation between property rights and immigration status, which is often misunderstood. It stems from the fact that property rights are largely universal. You don't necessarily need to be a citizen to own land, but the right to live and work in a country is a sovereign privilege tied to specific national interests and immigration policies. So while you can own a piece of America, it doesn't automatically mean America grants you residency. It's a very important distinction to internalize.
That's incredibly clear and really important for managing expectations. Okay, let's take a look at the bigger picture for a moment. Is this entire phenomenon, of non-citizens investing in U.S. property a widespread trend? Who exactly is investing in U.S. residential property from overseas? It gives us a sense of context for how common this activity is and who the key players are.
You're right to ask about the broader landscape. Foreign demand for U.S. residential properties remains quite robust and is a significant part of the market. In 2024, for instance, overseas buyers purchased about $42 billion worth of U.S. residential real estate.
42 billion. Wow.
Yeah, it's a big number. To put that into perspective, that accounted for roughly 54,300 homes across the country. These aren't insignificant numbers by any means. They clearly highlight a strong, sustained international interest in the U.S. real estate market. It signals that you're certainly not alone in considering this kind of investment. When we break down who these top overseas investors are by dollar volume, the list typically includes countries like China, Canada, Mexico, India, and the UK. What's particularly interesting to observe is that India's share of these investments has been rising steadily in recent years.
Interesting.
Yeah, this trend often correlates with factors like increased economic prosperity in these countries, robust international trade, and growing numbers of their citizens pursuing education or professional opportunities in the U.S., who then look to establish a more permanent tie through property. These buyers are often looking for stability, potential appreciation, and sometimes, a tangible asset in a foreign currency. They frequently focus on properties in major urban centers or areas with strong job markets like New York, California, Texas, and Florida, which offer a combination of investment potential and diverse communities.
So if we connect this to the bigger picture, you can see that you're part of a significant global trend. It's not an isolated decision. Many individuals and families from around the world are looking to the U.S. for property investment. But this also powerfully underscores the importance of being incredibly well-informed and meticulously navigating these unique rules, especially given the nuances of your immigration status. You're definitely not alone in this endeavor, but that doesn't mean you can afford to be uninformed or careless. And that brings us, I think, towards the end of our deep dive into U.S. property ownership for non-immigrant visa holders. It's been a really comprehensive look at a complex topic.
We've covered a lot today, haven't we? From the fundamental permission to own property in the U.S., to the absolutely critical difference between passive and active involvement when it comes to managing that property. We also discussed the practical, compliance steps you can take, like hiring a professional property management company, and touched on other significant considerations like financing and local property taxes. Remember, ownership doesn't confer immigration status, and truly understanding these distinctions is key to protecting your visa while benefiting from your investment.
So for our final thought for you to ponder today, considering all these nuances, what kind of long-term real estate investment strategy aligns best with your personal financial goals and your current visa requirements? Are you looking purely for property appreciation, or are you hoping for rental income? And if so, how will you ensure that income remains genuinely passive and fully compliant with your immigration status? These are essential questions to ask yourself and really plan for before making any moves. A short brief, as we've discussed, the core takeaway is this. While owning property on an H-1B or other non-immigrant visas is permissible, engaging in activities that resemble direct management or business operations can jeopardize your immigration status. It's that simple. Prudent, hands-off ownership, often facilitated by professional management, is the safest path. And if in doubt, consulting an immigration attorney is always your safest bet. Don't hesitate, all the best, and we will meet again with another important subject in the next week.